we will get started. Brian?
First, I'd like to thank you all for joining us today for the Council of Oil and Gas Attorneys webinar, Pore Space Law and its application to CCUS. This webinar has been accredited in Texas and Oklahoma for 1 hour of continuing legal education credit. And this topic actually came up in our council about 1.5 years ago. And today's CLE is a product of, I would say, the patience and hard work of IOGCC staff, Amy Childers and Lori Rotenberry. So I appreciate their opportunity to give our council the opportunity to host this CLE. And with that, I will turn it back over to Amy Childers.
Okay, thanks, Ryan. Glad everyone could make it today. Before we start, I just wanted to remind everyone that this webinar is being recorded. I would also like to run over a few points of information about how we will run this webinar. All attendees are muted except for the panelists. Everyone will remain muted during the presentation. If you have a question after the presentation, please raise your hand. You can do this by clicking raise hand at the bottom of your screen. I will unmute you to allow you to ask your question. When I do call on you to answer your question, please introduce yourself by stating your name and your organization. We have disabled the chat and the Q&A function, so raising your hand is the only way your question will be heard. Now I'm going to kick it back to Ryan to introduce our presenter.
Thank you, Amy. It is my great honor to introduce Joseph Schremer as our speaker today. Joe is currently the Judge Leon Karelitz Oil and Gas Law Professor at the University of New Mexico School of Law. He teaches oil and gas, property law, business law, and commercial law. If you have researched this subject whatsoever and looked for a legal article on pore space ownership issues, you've undoubtedly run across one of Joe's articles. I know Joe from his time before being a law professor at New Mexico when he was here in Kansas and practiced, and I was a little sad to see him go. It's always hard to lose a respected member of your bar, but thankfully he still comes back and participates through our CLEs. With that, I will turn it over to Joe and look forward to hearing your presentation today, Joe.
Thank you, Ryan. Thank you, Amy. Thank you to the IOGCC, and thank you to the Zoom gods. If I'm able to share my screen, let me try. Okay, how do I look? I'm going to presume that I look okay, unless somebody tells me to the contrary.
There we go. Perfect. That was perfect.
Marvelous. All right. Well, like most law professors, I am prone to delusions of grandeur. And so the way that I tend to think about our topic here today is as the birth of a new subfield of law, almost akin to what lawyers would have been encountering 140 years ago with the birth of the subfield of oil and gas law. Now, it's a little dramatic, but I think as we go through the presentation, you'll see at least some shades of what I'm talking about when I talk about the birth of what I'm calling pore space law. So before we begin anything, let's all get on the same page about what we mean by pore space. The crust of the earth is made up of a bunch of rock layers stacked on top of each other. Most of those rock layers are sedimentary rocks, which means that they are formed by little bits and pieces of other rocks getting stuck to each other. And they look a little like concrete because that's functionally what concrete is. So when these bits and pieces get stuck to each other, they're not aligned perfectly. They don't sit nicely, cleanly adjacent to each other. Instead, a lot like concrete, there's these little gaps in between the parts and pieces that make up the sedimentary rock. Now, they're microscopic gaps, But they're gaps nonetheless. And those gaps mean that the rock, even though it looks to us like a rock, is actually more like a sponge. And like a sponge, has the quality of porosity, in which inside the porosity, it can hold fluids like air, but more commonly salt water, and hopefully oil and gas. Now, these little voids we call pore spaces. To be useful as an oil and gas reservoir, one of these rocks needs to both have the characteristic of porosity. It's got to have these voids. It's also got to be at least minimally permeable, which means that the voids have to talk to each other. There have to be little connections or throats between the pores. And it's that permeability that, together with porosity, allows oil and gas to flow throughout these rock layers. And that's why oil and gas law is so interesting, because oil and gas moves underground in response to changes in pressure throughout that rock formation. As it moves, it's moving through these pore spaces. We've known this for a long time, and we've been really keenly interested in producing oil and gas from these reservoirs for a long time, and regulating the production of oil and gas from these reservoirs. But it's only been relatively recently that we have started to think about the pore spaces themselves, the storage capacity of the rock, as a resource separate and apart from the oil and gas that it contains. And that's because, although we have been injecting things into that porosity for years and years and years, things like wastewater from oil and gas production, things like natural gas to trap it in there in that pore space to sort of store it for future use. There's just been so much of the pore space and so few things to do with it that we haven't really thought of it as particularly scarce. And as a consequence, I think we don't have a lot of law around ownership and use of that porosity itself, separate and apart from its uses in oil and gas development. That has all changed, or is changing, I guess I should say, with the development of CCUS, carbon capture, utilization, and storage. So I won't go into a lot of detail about CCUS, but we are going to talk a little about what it is, its two primary manifestations, and what kinds of practical problems they tend to bring up in the world, as a way of framing our discussion of the development and the current state of pore space law, so that we can talk about how pore space law and CCUS interact with each other, so that we, in the third part of the lesson, can talk about how through statutes and regulation, the state can sort of control the conservation of pore space, the use of it, and the development of it. So what is CCUS? Like I said, it stands for carbon capture, utilization, and storage. The idea here is that we don't want carbon dioxide to make it into the high atmosphere, so we trap it from the sources of it, sources being mostly man-made sources like coal-fired power plants, ethanol plants. We grab or capture the CO2 from the point of emission through a pretty significant technology, and we reduce it to possession. We stuff it into a pipeline, and we move it by pipeline into a field where we can inject it into the earth for some purpose. The first purpose of capturing the carbon is utilization, the U. And what it really means is stuffing it into the ground for enhanced oil or gas recovery. So EOR. Won't go into very much detail about EOR because I'm guessing that on the technical side, many of you know much more about it than I do. But as a high conceptual matter, the idea of enhanced recovery is to produce the residual oil and gas from those reservoirs that are significantly depleted. And that requires some extraordinary feat. And in particular, what we use CO2 for is to inject the carbon dioxide that's been captured into the depleted reservoir both to help increase its pressure again to make it more productive, but also to move and suck the residual hydrocarbons toward a well that is going to produce them. And then we produce the residual hydrocarbons through the producing well. And of course, up comes CO2 along with it. So we split those streams off. We sell the oil and gas, and we bring the CO2 back to an injection well where we re-inject it in a circular process. The circular process is made possible by the miracle of nature that we call pore space. It's through those pores that all of this stuff, all of these fluids are moving. And of course, because it's not a perfectly efficient system, a lot of the CO2 that we inject in an EOR operation gets sort of lost down there. It just winds up in the pore space, sequestered, you might say, in the pore space, never to be produced through the extraction process. And so we both produce oil and gas with it, but we also end up sequestering a very large percentage of that CO2 ultimately in the pore space of the subsurface rock formation. We call that utilization because we are using the captured CO2 for another beneficial purpose, oil and gas production. Contrast that, which we have, by the way, been doing for a very long time. Contrast that with the S part of our acronym, storage, or pure sequestration. The idea here being that capturing the carbon dioxide, stuffing it into a pipeline and taking it to a field and sticking it underground is valuable for its own sake, primarily because it means that we have generated the electricity, we have created the ethanol, we've done whatever the beneficial thing is that emits the carbon dioxide, and we have done it without the carbon dioxide leaking into the atmosphere and enhancing the greenhouse gas effect. So we stick it underground permanently with no hope that it ever escapes. And that's the only purpose. We're not utilizing it for anything else. We do this by sticking it underground in a variety of different kinds of rock formations. We do use depleted oil and gas reservoirs for this because it's got the porosity, the permeability that we need. And another important type of place to stuff this into pore space are in deep saline aquifers. That sounds fancy, but all that is a sedimentary rock layer that has porosity that is full of salt water from an ancient inland ocean. And we can stuff the CO2 into the pore space there. It's also possible to stuff it into certain kinds of coal bed formations, although somewhat less of the target. We really focus on depleted oil and gas reservoirs and saline aquifers for this. Now, when we do this on the permanent storage side, which is, I'm going to talk about both utilization and storage today, but the storage is really going to be our primary focus because it raises some novel issues the law hasn't dealt with before. We need to have certain facts in mind, certain, you might say, legally relevant or problematic facts. The idea is that we're going to stick this stuff down there for eons. We're never bringing it back up. When we stick it into an injection well, it doesn't just go to the reservoir formation where the well is open to and stay there. It moves, just like oil and gas drain through pore space into a well bore intended for extraction. When you inject fluid into a reservoir, it moves through pore space in a lateral, sometimes vertical, but ideally not, but always in a lateral direction across the pore space throughout the extent of the formation. And that plume of injected CO2 moves over a very long distance. We're talking about hundreds or thousands of square miles of subsurface rock formation being consumed laterally by injected CO2 for a large permanent storage project. It's not just the plume of carbon, though, that's moving in that lateral direction. It's also ahead of it a pressure plume, because what we're doing by injecting is we are increasing the pressure of the reservoir. That's necessary in order to get the stuff to move through the pore space. And so as we're affecting the reservoir laterally, we're moving not only CO2 through the pore space, we're also just moving a little cloud of pressure out ahead of it. Of course, this also tends to happen in places where we have good porosity and permeability. That's also where we produce oil and gas. And we also tend to see these projects crop up in areas where we have a lot of geological information already. We already know about the characterization, the stratigraphy, the lithography of different subsurface formations, which just makes the preparation process a lot faster and cheaper. Of course, we know that information from historical oil and gas production in the area. So carbon sequestration, the permanent storage, and oil and gas production, they just happen in the same area, which turns out to be a real problematic fact. Now, this is not the total Wild West. There are laws that already apply, both to EOR, of course, as you know, but also to permanent storage. And they are primarily at the federal regulatory level. These are not laws of property. Those are what we will mostly focus on today. These are regulatory laws. And to have a clearer picture of how the law of property is developing around this, let's talk a little about the state of federal law. Under the Federal Safe Drinking Water Act, you need a underground injection control permit to inject pretty much anything into the subsurface of the earth, because we have underground sources of drinking water down there that we want to protect from contamination. So you need a UIC permit to inject, whether it's for EOR or for permanent storage. Different permits, of course, we all know, we're all intimately familiar with the Class 2 permit. But we are not nearly as familiar, most of us, with the Class 6 permit. That is the necessary class of permit that you need to inject carbon dioxide into pore space for permanent storage. It is a much different kind of permit. The EPA has primacy over granting these permit applications over most states. There are a couple of states that do have primacy. Looking at you, North Dakota, looking at you, Wyoming. There are other states that are in the application process, or if I'm not up to date, have already achieved it. Looking at you, Louisiana. But mostly we're not asking the State Conservation Commission for this permit. We're asking EPA, and it is not much like getting a Class 2 permit. It is much more onerous. A lot more science has to go into delineating the reservoir, showing that it is likely to be contained, reviewing a much larger area of lateral reservoir than you have to look at for Class 2 permits. It's just a different beast. And in fact, in the practical scheme of actually doing a permanent storage project, this is a real choke point. This is where projects go to at least really slow down and often totally to die. That all I'll say about the permitting side of things. But you might ask yourself, well, why on earth would anybody do this other than pure altruism about the environment? Well, it's because we, and by we I mean mostly the federal government, have enacted laws to give very rich tax credits to operators that are able to store carbon dioxide, either incidentally through the EOR process, like we talked about, or through permanent injection and storage. And that's the 45Q tax credit. It was it's been on the books for a number of years. It got a lot richer after I think it was the Inflation Reduction Act. It increased the amount of tax credit available per ton. You can see that you get more of the tax credit money for storing the stuff permanently and less for the utilization side of things. These are transferable now. That was not necessarily true before the Inflation Reduction Act. And also really important here, the Inflation Reduction Act made these tax credits what we call direct pay, which means you qualify for them by stuffing carbon into pore space. The government sends you a check, whereas otherwise, before the Inflation Reduction Act, before it was made direct pay, you had to have a real tax appetite for tax credit. You had to have a lot of taxable income to even care about these, because you had to have some income to apply them to. That limited how you could do these deals. Now it is much wider open. So we think this is going to happen. And in fact, it's happening slowly in some places, a little quicker in others, but it is happening. And so now we see the pore space itself as a natural resource, sort of standing alone from the oil and gas that it contains. And this requires us, just like the discovery of oil and gas production did in the 19th century, it requires us to start thinking about what the ownership of pore space looks like, who owns it. That's sort of question number one. Who owns the pore space and can use it? Question number two is, how can you use it? When you own it, what property rights come along with it? And really, we define that when we talk about the extent of ownership rights and property law. We typically define that by talking about what you cannot do with it. So we sort of look at the second big question of how can it be used and how is it not permissible to use as it pertains to someone who owns the oil and gas that may be within the pore space. And then number three, we ask ourselves, well, how can you use it or not use it as it pertains to all of the other landowners or pore space owners next door to you who also own their pore space? How can you use it with regard to them? So we have sort of three big overarching questions about ownership and use of pore space as it pertains to CCUS. And we're just going to dive into each one of them sequentially, starting with who owns the pore space. Of our three big ownership related questions, this one is by far the most settled. In fact, my opinion is the opinion of most oil and gas professors I know, and the opinion of most informed practitioners I know, is that ownership rests with the owner of the surface estate of a tract of land. Let's talk a little briefly how we get there. Well, we start with these general principles that have existed in the common law for eons. And that general principle is the first one, the so-called ad caelum doctrine, which is often associated with our Lord Coke over here. He's a famous 18th century English judge. The doctrine says this: if you own land, you own everything above the land stretching to the heavens and everything below the land stretching to the center of the earth. It's all yours. Anything attached to the land or above the land, that's all yours. Now, that gets complicated as you go up because we've all flown on airplanes and we know we haven't trespassed on anybody's land by flying over it. So that's a topic for another day. Oil and gas lawyers, pore space lawyers, are interested in the principle as it applies down to the center of the earth. What it means is that all of the rock underneath the land is the landowner's. All of the little pore spaces in the rock, that's all the landowners. All the fluids contained in the rock, in the pore spaces of the rock, that's the landowners. Simple. However, every state in the union recognizes the power of a landowner to either by conveying through a deed to another person or reserving in a deed from a conveyance of the land to another person, can sever the mineral interest in the oil and gas and other minerals in the subsurface and create two separate owners of the land, one who owns the mineral interest now and one who owns everything else. So we call the mineral interest the mineral estate. We call the residual interest the surface estate. Now, the mineral estate owns only the oil and gas and the chance to get at it. And the surface estate ordinarily hangs on to everything else, including the pore space. So unless there is some unusual language in the conveyance that creates the mineral estate, the surface estate owner in a split estate owns the pore space. Big caveat here for those of you practicing in the West. Under the Stock Raising Homestead Act of 1916, the United States, when it patented lands to homesteaders, it reserved basically all of the subsurface. Now, it reserved minerals, but courts interpreting the breadth of that reservation have basically said the patentee, the surface owner, literally just gets the surface, and then everything underneath more or less belongs to the federal government. So if you're dealing with land patented under that particular Homestead Act, we may have a different situation. But if you're dealing with private land that is patented under some other act or has a different title, chain of title, we're talking about pore space ownership being in the surface estate. And really that's not very controversial at this point. Some states have declared that to be true. They've codified that principle through statute. Many have not. But even in those states, in my opinion, that have not codified it, it should be a pretty uncontroversial conclusion. Much more controversial and less developed and less thought about is how you can use your ownership interest in the pore space. To what extent do you have the right to use it? And that's really a question that I divide into two different questions. And it's really important that you follow me in this part of the sort of the introduction of the second half of the talk. There's really two different issues here about how you can use your pore space. Issue type number one is what on this slide I'm calling shared tract interference. This is not complicated, but it arises every time within one tract of land, ownership of the surface and the minerals is split into two different parties. The minerals are severed. Okay, so when we talk about shared tract interference, we're talking about the rights of the pore space owner, the surface estate usually, to use the pore space with due regard for the rights of the severed mineral interest in that same tract of land. That is one set of questions about the extent of pore space ownership rights. We're going to look at that one first. And then we'll look at the second question. But before we look at it, I want to delineate the second question and show everybody that these really are two different questions. The second question, the orange part of my slide, is what I'm calling offsetting tract interference. It's what we usually talk about as subsurface trespass. This is where the owner of pore space wants to use the pore space in a way that is somehow going to interfere with the owner of pore space in a neighboring tract. Okay, so shared tract versus offsetting tract. These are the differences. We're going to start by looking at ownership and use rights of pore space within a split estate in a shared tract of land. Oil and gas lawyers in the audience, you all know the basic law here. And I'm basically just drawing an analogy from the well-known principles of split estate law. It goes like this, where in a single tract of land, the mineral estate is severed from the surface estate. The mineral estate gets, whether by express language in the conveyance that creates the mineral estate, or by implication by law, gets the rights to use the surface estate as reasonably necessary for the enjoyment of the underlying minerals. Right? We don't recognize an ownership interest in something that doesn't include the rights necessary to use and enjoy it. So we have this implied, or depending on the language of the instrument creating the mineral estate, an express surface use easement. And it allows, unless the express language makes it more narrow, it allows generally reasonable use of the surface estate in order to enjoy the underlying mineral estate. Now, that does not encompass using the surface estate to develop or enjoy minerals that underlie a different surface estate. Right? So you can't benefit other lands by using the surface of the servient estate here, but you do get a pretty broad surface use easement here. Now, the easement that the mineral estate gets is over the surface estate. That we have already defined to include the pore space. So pore space in a split estate title and land is owned by the surface estate, but it's subject to the implied easement rights of the mineral estate to use as reasonably necessary for oil and gas production. So what's that mean? Well, it means that we have a potential conflict over the surface owner using its property of pore space for either, well, in this example, for storing carbon dioxide versus a mineral interest owner's right to use the pore space for purposes that are related to its oil and gas production. So which, as between these two, would get to do EOR with the pore space, inject the carbon for utilization? That's right, friends. It'd be the mineral interest, because the mineral interest has the easement right over the pore space to use it to enjoy its minerals, and EOR is intended to enjoy the mineral estate. But who would have the right to inject carbon dioxide into the pore space for permanent storage? Well, friends, that has nothing to do with mineral development, using and enjoying the mineral estate. So it is certainly outside the implied surface use rights of the mineral estate, which means that that right to do permanent carbon sequestration, that rests with the surface estate. So you can imagine a scenario. This will happen in places, if it's not happening already, where you have a mineral estate that wants to make use of its pore space for any reason, drilling into it to produce it, drilling into it to dispose of salt water, drilling into it to use for EOR, versus a surface estate owner that also wants to drill into its pore space to use for carbon sequestration, permanent storage purposes. Okay, so we're going to see conflicts that happen within a shared tract between the split estates. Each one is going to want to build well pads. They're going to need places to set ancillary surface facilities. They're going to need access through roads. They're going to need to drill potentially conflicting well bores in the subsurface. Here's one for you that should be on your mind. We may have a situation where a surface owner wants to use pore space in a shallower formation for carbon storage, and we have the mineral owner in the same tract who wants to use a deeper formation for mineral extraction. But how does the mineral estate get access to the deeper formation to extract the minerals? Well, you've got to drill through the shallower formation that is in use for carbon storage. And the drilling through problem, I think, is going to raise, if not a lot of lawsuits, at least a lot of hackles among carbon storage operators who are strongly incentivized not to allow anyone to drill through the plume of carbon. Both because if they lose control of the carbon, they may be liable under their Class 6 permit. They may lose their tax credits, have to pay the IRS back their tax credits. And there's also a tax credit program for carbon sequestration through the California Air Regulatory Board, CARB, that pays you only if you ensure contractually that no one is allowed to drill through your carbon plume. So the drilling through problem, I think, is a one really concrete place where the split estates are going to end up fighting each other over use of pore space. There's not much we know about this. This is by far the most understudied part of the developing body of pore space law. I'm working on a paper on it right now, but it's not done yet. And I don't think there's really much out there yet. Certainly no directly on point case law, but there are some things we know. We know that the mineral estate is dominant over the surface estate. That's just back to good old-fashioned easement law. So the mineral estate is going to get priority in most situations to use the subsurface, including the pore space, where their uses conflict in any of the ways I just described. However, in many jurisdictions, at least certainly Texas, more questionably Oklahoma, who's never expressly adopted it, the mineral owner may have an obligation to accommodate the surface uses of the surface estate owner under certain circumstances. In fact, in a subsurface trespass case, Lightning Oil, several years ago, the Texas Supreme Court expressly said that the accommodation doctrine would apply subsurface. So We haven't seen any more cases about that. I think that is a ripe area for study and certainly for litigation. But we at least know those basic principles that apply at the surface are going to apply at the subsurface too. But there are some things we don't know. Here's one I want to pitch to the oil and gas lawyers out there anyway. One thing we don't know is if the surface estate owner doesn't want to conduct carbon sequestration itself, but instead wants to give some third party the right to do so. How can the surface estate owner do that? Can it accomplish it through severing an estate in the pore space, the way that we acknowledge that landowners can sever an estate in oil and gas? No one knows. Can it be done through leasing the pore space? Perhaps that would be sort of like a wind lease or a solar lease, you might think. Can it be done solely through the execution of an easement? Now that would look a little like a pipeline easement, I think, where the landowner grants to a pipeline company the right to put a pipeline on the premises and leave it there as long as it's using it. Well, an easement for carbon storage might say to a carbon sequestration operation, you're allowed to let the carbon be under in my pore space under my land. You have an easement to that effect, and you can leave it down there according to your subsurface easement. Can they do that? Presumably, of course, they could. But what kind of priority would exist among a surface estate owner, a mineral estate owner, and one of the grantees of any variety of property interest in the subsurface pore space? Again, not well studied, a lot of unknowns there. Number two, many states have passed surface damage acts or surface owner protection acts to modify all of these common law legal principles about use of the surface. Do those acts apply underground? Some state courts have dealt with that issue and said, yes, Montana's does. North Dakota's did, and then the legislature amended the statute to expressly exclude pore space. So there's a lot of activity going on there as well. Could talk all day about that, but we've got to move on to the next sort of third big looming question about pore space law, the subsurface trespass question. So now we're not talking about shared tract interference anymore. Now we're talking about carbon dioxide injected in one tract by the owner of the pore space, migrating through the porosity into another tract, or maybe hundreds or thousands of other tracts that have not given their consent to the entry into their pore space of the carbon dioxide. And this could manifest any number of ways. It could simply be a protest by a landowner that says, I don't want that stuff down there. You have infringed in my exclusive possession of the subsurface. It could arise where a mineral owner argues that somehow the carbon plume has interfered with the mineral interest owner's ability to produce its oil and gas reservoir, or perhaps it has been injected into a deep saline aquifer that's also used by oil producers elsewhere for disposal of salt water. And the carbon plume and the pressure plume have increased the pressure needed to inject into the saline aquifer for class 2 purposes, and now we have a trespass claim. We can imagine a lot of different nightmare scenarios where you inject something into the earth and it spreads out underneath lots and lots of landowners' property. Unlike the shared tract interference question, this has gotten a lot more attention over the years, and it has been on the mind of lawyers and scholars and judges for a decade or more in the fracking context. And we have a lot more legal principles and analogous cases to draw from here. The problem in the subsurface trespass area is that it is horrifically disorganized. It really is. Go open the Williams and Myers treatise. You cannot find one chapter that says, here are your subsurface property rights vis-a-vis your neighbor's subsurface property rights. You might think you can, but in fact, what you find are chapters and sections and subsections on a dazzling array of different doctrines that all together are sort of a family of the law of oil and gas reservoir ownership and trespass, but none of them alone give you a complete answer. So a lot of the task here in determining when sequestration or storage of carbon dioxide is going to be a mineral or a trespass on some other property owner's subsurface property rights is just organizing what the law surrounding oil and gas ownership already is, and then drawing an analogy to that to answer the pore space trespass question. With that in mind, I want to go through a few of these doctrines, this potpourri of or array of doctrines, and a few cases that that we know the answers to, and then a few cases where we're a little less confident about the answers to, and then synthesize for you a rule, or really more of a sort of a standard or a test for when one person's use of their shared pore space interferes with a neighbor's use of the pore space in a trespass. Okay, so bear with me here for just a second. The lawyers might enjoy this, or maybe not, but I'll try to make it accessible to everybody. The first potpourri of the doctrines is the venerable rule of capture. It says if you drill a well located entirely within your own tract of land to extract oil and gas from a common reservoir, whatever oil and gas you extract from that well is yours, regardless of where it came from in the reservoir. Even if it came from underneath your neighbor's property, that is your oil and gas. That might make you think that if you inject anything into the subsurface, in a well that is located only on your tract of land, that you must be doing something right. Even if it goes underneath your neighbor's land, it doesn't trespass them. That would be, I think, a mistake. Number two, in relating to why that might be a mistake, is this doctrine of correlative rights that says, yes, you have the rule of capture. However, in exercising your capture rights, you have to respect the correlative capture rights of everyone else who owns an interest in that same common reservoir. You can't act unreasonably. You can't injure their rights. And it is it is easy to say, but hard to spell out exactly what constitutes injuring other owners' correlative rights. You have the negative rule of capture, one that I think is especially important for our discussion here today. And when lawyers talk about the negative rule of capture, they often mean it to say that when you inject into a well on your property, then you are not liable for any of the consequences if the stuff you've injected goes into your neighbor's land. The inverse or negative of the rule of capture. I think it's a mistake to read it that broadly. We will look here in a moment why I think that's a mistake. And then finally, you have this classical doctrine of subsurface trespass that says the rule of capture doesn't apply if your well is drilled into the land of another person. If you cross the boundary line and suck the oil and gas directly from underneath their ad coelum defined boundaries, that does not entitle you to the oil and gas. You have instead trespassed, and you're liable and to the neighbor that you trespassed on, and they own title to the oil and gas. So that's just a sampling of the doctrines. They work out pretty well in most cases. We have a lot of easy cases. The first one here is the deviated wellbore case, where you drill a wellbore into your neighbor's land. That's the classic subsurface trespass. That's always actionable. Number two, we know for a fact that if you inject stuff into the earth, even if it's for a water flood, and you cause neighboring wells to water out, you damage offsetting mineral interest owners' ongoing oil and gas production, that's actionable. We got lots of cases like that. The Tidewater case from the 10th Circuit is certainly one of the famous ones. We know that to be true. We also know that if you drill into a common reservoir and you do something negligent to destroy it, for instance, you let the well blow out, we know that violates your subsurface neighbor's correlative rights, and that is actionable. These are all easy cases, but we have lots of hard cases too. The top two are by far the most important for us. Number one, I call this a hard case. We have some cases out there that say if you inject into a common reservoir for secondary or enhanced recovery purposes, and you have a permit from the the conservation regulation body with jurisdiction, then that is not an actionable trespass, even if it sweeps oil and gas from underneath a non-consenting owner's tract and produces it from your wellbore. That is not a subsurface trespass. The famous case there out of Texas, of course, is Manziel. The rationale for the case was largely public policy reasons. And it might make us think, well, this is an open and shut case. At least in the EOR context, you don't have anything that you can call subsurface trespass liability. Pause there for a moment. Oh, and by the way, this is the case where we get the so-called negative rule of capture. But you need to pause there for a moment because Manziel is narrower, I think, than we often read it to be. Manziel was a claim for injunctive relief against the enhanced recovery operation. The court said, we are not going to grant injunctive relief to stop an operation that is being done with the blessing of the state regulatory commission. They're the railroad commission. The court does not hold that there's no trespass liability for damages. It doesn't hold that. And we have other cases in other jurisdictions that would strongly suggest that that is really not the full breadth of the principle at work there. We have this second difficult case that's really important to us. And it's the trespass by fluid injection, the Chance versus BP Chemicals case. We've got BP Chemicals. They inject into a common reservoir, a saline aquifer, actually, some nasty hazardous waste. Landowners who own land over the aquifer, they sue. And the court says, nope, you need to show actual harm in order to have a subsurface trespass case. Again, the rationale for that was not property doctrine. It was instead public policy. Another couple public policy difficult trespass cases are Garza and Lightning Oil. Everyone's generally familiar with those. They're less important to us here, so I will skip straight to our synthesis. What you find if you try to give a reasonable interpretation to all of these cases, and you don't rest simply on matters of public policy, is this secondary enhanced recovery operation good for society, and does the good to society outweigh the property interest of the trespassed upon landowner? Is a permanent storage of carbon dioxide good enough to allow for trespasses onto neighboring landowners without getting into the public policy, being totally disinterested in society's interest in these things, using only the property law? You can synthesize this basic doctrine that I think works pretty well. The idea of subsurface property rights, whether they're in oil and gas or pore space, is that they don't give the owner any exclusive possession or use. They can't. They're interconnected. They physically can't. All they give the owner, whether it's oil and gas or pore space, is the right to use it. And everyone who owns pore space in a shared reservoir has the right to use it. And so their rights cannot inflict on other rights holders an injury to their rights. That's what makes them correlative. So everyone has this equal, fair chance or fair opportunity to use the pore space. And that, in determining how or under what circumstances use of it will injure someone else's fair opportunity to use their pore space, you can't look simply to any one doctrine. You got to try to synthesize them all. And what that looks like is, if you have one owner that takes an affirmative action like injecting carbon dioxide into a shared reservoir, and it invades some other owner's subsurface property, and either damages it through physically harming the ongoing subsurface activities, like watering out oil and gas wells that are trying to produce, you have liability. You may also have liability for trespass, even if you have not directly actually harmed any ongoing activity like a producing well, if by letting that stuff migrate into your neighbor's pore space, you have precluded them now from making a use of the pore space themselves. If you've shut off their fair opportunity to use the shared pore space for beneficial purposes, you have injured them, you have infringed their property right, even though you haven't actually harmed their ongoing activities. With the exception that if before precluding the neighbor by occupying all the pore space with your carbon dioxide, you have made a fair offer to them to participate along with you in the use of all that pore space throughout the reservoir. If you've made that offer and the other side said, no, we don't want to go along with it, they are then precluded from suing you for subsurface trespass. I didn't just make that up. There are cases like that. There's a case called Tidewater versus Stock. There's a case called Reed. A very famous one out of Nebraska is called Baumgartner. All of these involve an offsetting interest owner that does not want to participate in a unitization of the subsurface common reservoir, withholds its consent from a reasonable offer, and is later precluded from suing for subsurface trespass that results. For the lawyers in the audience, that rests on principles of unjust enrichment and estoppel. But what it means for all of us in terms of using pore space for carbon sequestration is that if you are a carbon sequesterer, a pore space owner that wants to fill up a reservoir full of carbon, you may have, under the common law principles, you may have the right to make an offer to all of the interest owners whose pore space you're going to use to participate, to come along with you. And if that offer is fair and reasonable and non-discriminatory to them, and they turn you down, they've acted unreasonably, they have essentially turned down their opportunity to use that pore space themselves. And instead of suing you for trespass, you get to use their pore space. And they would probably, under unjust enrichment and estoppel principles, have a hard time suing you for subsurface trespass. That's the thrust of our fair offer exception that we have outlined here. In the interest of time, let's move now to how states have started to solve these problems with statutes. And the reason they have started to solve these problems with statutes is perfectly rational. All of the common law principles I just talked about, those have not been applied in these cases, in the permanent storage case at least. They've not been applied. We don't know exactly how courts think they operate. All that we can do is give our best legal interpretation of them, like I have just done in my own synthesis. Right? So there's a lot of uncertainty there, which makes capital investments in carbon storage projects exceedingly risky. So states have acted. They've really done two different things. One thing that the states have done is they have enacted statutes that essentially give unitization authority to carbon sequestration operations. To say, just like an oil and gas operator can seek compulsory unitization of all of the interest owners in a common pool of oil and gas to allow for enhanced recovery of that as in field-wide operations as a unit. We're going to give statutory authority to owners of pore space interests in a common reservoir who want to compel other interest owners in the reservoir to go along with their carbon sequestration project. Because the principles that apply to correlative rights in oil and gas should apply to correlative rights in pore space, pooling and unitization statutes ought to operate similarly. They're drafted to operate similarly, and they ought to be upheld under the same kinds of constitutional principles that have upheld, I think, the unitization statutes. That I know of. There may be people in the audience who have knowledge that I don't have, but that I know of, while these schemes have been adopted in certain states and they look like they could work, I don't know of anyone who's actually tried to make them work. I don't know of any applications. My guess would be Wyoming is going to be one of the first states to see something move through the process. I don't know of any cases that have tried it yet. So there's going to be a lot of bugs in the system. It's going to be a little difficult to work out. But I do think that they are well justified because they essentially codify the principles, including the fair offer exception that I just synthesized from the common law. The other side is to grant eminent domain condemnation authority to carbon sequestration operators to condemn the pore space ownership in a reservoir in order to inject carbon dioxide for permanent storage without even worrying about the possibility of trespassing into someone else's pore space in the reservoir. So Louisiana has a very robust eminent domain statute. Again, not familiar with its being used to actually enable a carbon sequestration project yet. It's early days down there. But Indiana is another state that has tinkered with it in sort of a pilot project sort of way. That's a sort of simpler, more streamlined way to handle this. But I think a little bit more foreign to oil and gas lawyers. And candidly, as someone who's worked on a little bit of legislative drafting in two states that have no legislation on bringing pore space ownership together, it seems to me there's a bigger appetite among landowners and oil and gas interests for the pooling and unitization model than the eminent domain model. But I don't know. I don't know that for sure. One thing to be aware of is that in passing regulations and statutes to make carbon sequestration and EOR more possible without the threat of subsurface trespass liability, states can run afoul of property rights. They can, in other words, affect regulatory takings. And this is a very recent case out of North Dakota that I'm going to talk about real briefly, and then we'll go to questions. But before I do, I want to mention that there's been some lawmaking down in Louisiana that I'm aware of, at least on the local level, the parish level, to ban drilling through carbon dioxide bearing formations for oil and gas purposes. That is another type of regulation of this area that I think could implicate some of the regulatory takings challenges that we'll talk about here with the North Dakota case. In other words, another developing part of this field that state regulators particularly are going to have to take into consideration when they're enacting statutes and regulations that regulate use of the pore space for these purposes. Northwest landowners, big case here. North Dakota has had on the books this first statute and amended its statutes to include this second one fairly recently, 2015 or something like that. And basically what they're trying to do with both of these, the legislature was trying to immunize oil and gas interests primarily, but possibly also carbon sequestration interests from the potential for subsurface trespass liability for liability to pore space owners for occupying the pore space with substances for either oil and gas activities like EOR or even just saltwater disposal or for carbon sequestration. That was the basic goal. Let's just, as a matter of state statutory law, preclude pore space owners from bringing a trespass action for the use of their pore space. That's the basic idea here. In Northwest landowners, we get a constitutional challenge to that new legislation. And the constitutional challenge is raised in what I called earlier the shared tract interference context. In other words, it was an as-applied challenge. The argument went as applied to the pore space ownership rights of a surface estate owner vis-a-vis a severed mineral estate owner in the same tract, by statutorily precluding the surface estate owner from seeking compensation for the use of its pore space under any circumstances by the mineral estate owner, the statute has infringed upon, or the constitutional language is taken, the property interest in the pore space of the surface estate owner. Why is that argument right? Well, it turns out it's right because the surface estate owner's interest in the pore space is subject to the mineral interest owner's use of the pore space for purposes that are reasonably necessary to develop the underlying minerals. However, in certain cases, and this is the focal case in the famous Mosser versus Denbury litigation, as well as in the constitutional challenge here, in certain cases, the mineral estate owner, under common law principles, could trespass, overuse its easement by injecting water for disposal that was produced not from wells benefiting the underlying minerals, but from wells that are producing minerals on another tract. That would exceed the implied use rights of the mineral estate and the surface estate's pore space. Ordinarily, before these statutes, that pore space owner could sue for trespass, which is to say shared tract interference, and gain a monetary recovery. After the statutes, that suit was precluded. And so the court found that the preclusion of that meant that surface estate owners had to suffer the occupation of their pore space by fluid injected by mineral interest owners. And that means that that essentially the mineral interest owners got a private right of condemnation of that pore space. They got to physically occupy that pore space for free, which constituted a per se taking under the Loretto case from the Supreme Court in the 1970s. It's a little weedsy, but what the big takeaway is that by modifying the property rights that we all presume exist in pore space under those general principles of common law, by modifying those by statute or regulation, states need to be wary that they may be effecting a taking of those property rights, and should probably legislate and regulate with that in mind. That is my last substantive slide. All of this is a lot. It might sound like lunacy or just be plain old confusing, but I have written about it in a much slower and more more deliberate manner in several articles. Here's a sampling of them. For the regulators in the audience who are looking for ways to justify constitutionally and otherwise their regulation of use of pore space for permanent storage, I would highly recommend the top article, which isn't quite done yet, but it is very close to being done. With that, I will yield, finally, the people said, and take some questions.
Frank Thorwald, I know that you had a question. You sent that through my email, but I can't get to it. Would you like to ask those questions? There you go. Go ahead, Frank.
Question with regard to long-term liability. Once the site is completely filled, no longer operated, at some point for insurance purposes, the operator/owner is going to need to no longer be liable for that. What's the directions that are being taken right now on that issue?
Well, there's a statutory solution to that has actually been enacted in law in some places, but not in others. That statutory solution is after a certain point, after the sequestration or the injection operations have ceased, if the operator can satisfy certain conditions, then it can apply to the state to essentially take ownership and liability over the entire facility from there until kingdom come. That is, I think, the industry's preferred situation. In states where that is not available to you, then you're stuck, right? The common law says that you're liable for it as long as it remains your property, and it remains your property as long as you haven't gotten someone else to take it from you. Of course, you could make contracts with insurers to insure you against any liability that results in the long term. But if the insurance market's appetite for insuring your risks 1,000 years from now is little, then you're just out of luck. You'll eventually probably go out of business, and whoever is harmed by your property will probably lack recourse against you, the operator, and may have to seek recourse instead against, perhaps on some kind of premises liability theory, the landowners under in whose pore space this stuff is stored. But it's a great question that needs probably a statutory solution that it doesn't have in most places.
What about a term of X number of years that the operator would maintain that, and then at that point it automatically go into the ownership of the state? So for instance, let's say 100 years or 60 years or whatever it might be, where it shows that there has been no leakage or issues. Could that be set up?
Oh, certainly could, again, by statute. And
Yes.
The statutes I'm aware of are way less demanding than that. They say after, 10 years or something, 20 years, not like 60 or 100 years after injection. So you, as a legislature in this area, I think you can adopt some reasonable, common sense liability assuming legislation to solve this problem. And I don't think that you have a lot of limitations that are not really political limitations in getting something like that passed.
Access to split estates. Where is the legal community going on this and the state's going?
What do you mean by access to split?
You have a split estate. You have one owner that owns the the pore space. You have another one that owns the surface. You need to go down to and to get to the surface to deal with that. What's the
the drilling through problem? I like to call it. Yeah. There are I believe Louisiana is an example of this. There are states whose statutes expressly permit drilling through a plume of carbon with regulatory authority to do so. And I think that makes a lot of sense. It could cause certain tax-related problems for carbon sequestration operations that are claiming California's low carbon fuel standards credit. However, I think it's a reasonable way to regulate the correlative split estate relationship. If you don't have a state that says you can drill through it with our approval, and then a bunch of regulations about what to condition approval on, things like integrity of the carbon plume, certain wellbore construction kinds of requirements. I think that makes a lot of sense. But if you don't have that at common law, your dominant mineral estate is likely to have the right to drill through. I would surmise, provided that it does so and not negligently. And that's probably not the uncontrolled drilling through. Is probably not what states really want. But I think in the absence of legislation, I think mineral estates are usually going to get to drill through. And then it's just up to the litigation process on the back end to clean up any damage that might occur as a result.
Let's add a second question, if I may, to that.
Okay. Go ahead, Frank. We'll give other folks to ask questions, so finish up with that question and we'll move on. Thank you.
Okay. All I was asking was with respect to tribal lands, where you have the split estates, which are a separate issue, and you have the federal government involved in the tribal lands.
That's a great question. I wish someone would write a law review article about that. But of course, you're gonna have the same basic issues in the use of that pore space as you have in resources development on tribal lands generally. So with obvious exceptions that I do not have enough knowledge about for Osage lands in Oklahoma that is subject to special regimes of statutes. You've got the basic trust relationship the federal government will have to approve. There may need to be some tweaking of certain statutory acts authorizing tribes to make their own deals, to include deals around use of the pore space. That's a great question that I don't think I have enough of the answers to.
Thank you.
Thanks. We have another question from Kenneth. Kenneth, will you please let us know what organization you're with?
Sorry, could you repeat that?
I'm trying to unmute Kenneth.
It's Ken White with White Exploration in Wichita. Joe, this is not a legal question, but earlier in your presentation, you were talking about the plume dispersal. And you first said 2 to 3 sections, but then you said 72 to 180 square miles. And I think I couldn't quite get to that many miles. And I just thought it's important to tell some of these people that, the dispersal of the plume, each well is going to be different, and porosity and permeability barriers, and you don't know which direction it's going to go. But I thought you were maybe scaring them a little bit with the number of miles you threw out there.
Well, thanks, Ken. Good to hear from you. I may be mistaken, and maybe my slide is a little clumsy, but the 2 to 3 sections number, I think, is per injection well. And projects are quite likely to have many, I know of one that might have 10 or 12 injection wells. And so there's a per well number out there, and then there's a total plume coverage out there. And of course, these are estimates. And they
So you were looking at a multi-well field.
that's a multi-well sequestration project. Yes.
Okay.
Thanks, Kenneth. Do we have any other questions? Anyone? Oh, here we go. Have Tim. Thank you. Let us know who you're with.
Can you hear me?
Yes, sir.
All right. Thank you. This is Jim Armbruster from Michigan, Department of Environment, Great Lakes and Energy. Right towards the end of your presentation, and I apologize if you might have said this, I had an emergency work call I had to take, so I could barely hear you. And I thought what I heard you say was, states that have oil and gas development have disposal wells with them. And if they're disposing of the oil field waste or brines down into these formations, they're putting them down there to leave them down there permanently, which would be into the pore space. Do you consider that actually a pore space, right? Should the lease agreements, in your opinion, be with the surface owners for disposal wells instead of the mineral owners?
The typical oil and gas lease will grant the lessee both the right to the oil and gas, but also the implied, or not, excuse me, not implied, the use rights over the surface estate necessary to develop the oil and gas. And typically that language is going to enable them to inject for fluid disposal into the pore space any produced water from that leased premises, because that easement, that surface use right is scoped to allow use of the surface to develop the particular underlying minerals. So if all you're doing is injecting wastewater produced from wells on that leased premises, or premises that have been validly pooled or unitized with that premises, there's no need to get consent from the surface owner, because the surface owner has already given up that right impliedly when it severed the mineral estate, either through a deed that preceded the lease or through the lease itself. But in order for the mineral interest owner to rightfully inject wastewater that is from wells serving minerals underlying other tracts of land outside water, well, that is beyond the scope of the typical surface use easement in a lease, and certainly beyond the scope of the typical implied easement. So there you would have to get the consent of the landowner to bring in outside water. Long answer to the need the surface owner's consent for outside water question.
Great, thank you.
Thanks, Jim. We have a question from Lori. Lori, can you let us know who you're with? Lori, I'm clicking ask to unmute. You may see something on the screen that you can click. So
Hello.
There we go.
Hello, my name is Laurie Williams. Joe, thank you so much for this excellent presentation. I'm an attorney and manager of Sutton Williams LP in Ardmore, Oklahoma. My sole question is, will this presentation be available for our reuse to show others?
Yes, IOGCC will make that available on our website, so it will be available. Yes.
Thank you so much.
Of course. Thank you. We've got William. William, do you want to ask a question? Let us know who you're with.
Hi, I'm Will Gallen. I'm with the Washington Geological Survey. I'm a geologist, not a lawyer. Oh,
I just made a mistake. That was on me. I just muted from Oh, there we go. William.
Hi, can you hear me?
Mm-hmm.
That's all right. I'm Will Gallen. I'm a geologist with the Washington Geological Survey. not a lawyer. My question is about Western states where groundwater rights might be severed from surface rights. And have you come across any issues with or any legal precedent with that, throwing in another twist, aside from mineral right?
That's a great question. So in a lot of your Western states, your surface and groundwater both are dedicated to public ownership and administration through the prior appropriation doctrine. And that means that that use of the groundwater implicates the state's ownership, so to speak, as sort of as trustee. It would be a state-specific question, but in general, the state does not own the place where the water is located, the pore space in those groundwater aquifers. So the use of that pore space, I don't think necessarily implicates the state's authority over the water resource. There is an interesting, at least in New Mexico, I know for sure that the state would also own those deep saline aquifers. Not necessarily, they're not subject to prior appropriation, but the state has ownership of the saline aquifers. And that was also the case in Chance versus BP Chemicals, that Ohio case I mentioned earlier, where part of why the court did not permit a landowner to sue BP for trespass, for allowing hazardous chemicals to be injected into and migrate through a saline aquifer into the landowners, beneath the landowner's land, was in part because the state owns the saline aquifer, according to that court, and not the private surface estate owner. So I think there would be some interesting issues around use of saline aquifers for carbon storage, but my interpretation would be that they would all probably weigh against giving a surface owner a right to sue for trespass against an injector. But it's kind of a complicated set of questions.
Thank you. And that state ownership of saline aquifers is that state by state, or is that
that'll be state by state too. In New Mexico, for instance, it's kind of a unique situation. In Colorado, will have its own situation, but probably most prior appropriation jurisdictions will claim ownership of the saline water, but I don't know that for sure.
Okay, thank you very much.
There
Well,
is.
I think we've probably hit our time there, Joan. We want to be respectful of yours. We know you've got things to get to. So thank you so much for your presentation today. And I think I'll turn it over to Amy to tell people how they can get their CLE credit.
Okay, thanks very much. Thanks, Joe. Ian, can we get that slide up? If you're from Texas and you didn't get the barcode, just let me know and I can get you that. So here's my contact information for those folks in Oklahoma that need to receive the CLE credit. We understand attorneys from some other states can obtain credit because the program has been approved in Texas and Oklahoma. Please contact me if you need information from us to meet your state's filing requirements. We will make Joseph's PowerPoint presentation available to you on the IAGCC website. Please feel free to contact me with any questions. And again, my contact information appears on the slide. Ryan, I think that's what we have.
All right. Well, I'd like to thank you once again, Joe, and thank you, Amy, for all your help in making today possible. With that, I think we can adjourn the meeting.
Thanks.